5 seconds to go. Start. However, the respondents submit that by virtue of dismissal of suit by First Appellate Court, all four brothers Julfi became owners and the sale deed executed in favor of the three sons of Bakshi Ram shall be subject to compromise decree passed by First Appellate Court. On 23rd February 1988, the present suit, Civil Suit number 41 of 1988, was instituted by respondents plaintiffs represented by their mother Premi Devi, hereinafter referred to as Julfi Ram and others, against appellant's defendants, hereinafter referred as Bakshi Ram and others. Thus, the erstwhile owners Mansha Ram and others were also implicated as defendants. The suit was filed for declaration and permanent prohibitory injunction, claiming that plaintiffs are owners in possession of half share, that is 3 canals 15 marlas in the suit land, as per the compromise between parties in civil appeal decided by District Court on 20th August 1984. Plaintiffs also stated that they continued to be in possession and they were cultivating the land. However, in June 1987, the defendants started interfering with the land in suit, stating that they have purchased the land and plaintiff cannot continue to cultivate. Only at this stage, plaintiffs claim to have received knowledge about mutation entries where only the names of defendants have been recorded. On the other hand, defendants Bakshi Ram and others submitted a written statement on 28th January 1992 contending that there was no compromise in earlier proceedings since no compromise deed was executed and placed on record before the court in appeal. They also claimed that they have spent rupees 9,000 on improvement of suit land after the purchase. The trial court, by order dated 19th December 1992, dismissed the suit. It held that for proceedings under Order 23, Rule 3 of Code of Civil Procedure 1908, the existence and production of written compromise between the parties duly signed by them is most important. It relied upon the ruling of this court in Gurupreet Singh versus Chaturbhuj Gopal. Since the said compromise was not presented in written form duly signed by the parties, the mandate under Order 23 Rule 3 CPC is not fulfilled and thus it lacks legal force. The trial court also held that statements before the district court cannot be treated as agreement or compromise. On the fact of possession, the trial court noted that plaintiffs could not prove that they were in possession and in cultivation of the land in suit as pleaded. As the trial court dismissed the suit, Julfi Ram and others preferred civil appeal number 17 of 1993 before the district judge Hamirpur. By order dated 21st December 2001, the district judge allowed the appeal, thereby decreeing the suit. It held that the trial court had no occasion to comment upon the legality of compromise because neither parties challenged the compromise decree by filing an appeal under Order 43, Rule 1A of CPC. Thus, it operated as res judicata and could not have been reopened in a subsequent suit. The said compromise would be binding on parties. On merits, it observed that the sale was clandestinely executed by the vendors Mansha Ram and others in favor of sons of Bakshi Ram. It further stated that even if the sale deed is considered to be valid, the same cannot be allowed to be acted upon as it has been executed during the pendency of civil appeal number 64 of 1993 between the parties. Stop.